Good morning and welcome to today's meeting of the Suffolk County Council Development and Regulation Committee. I'm Councillor Jenny Ceresa, Chairman of the committee, and I'll be chairing today's proceedings. This meeting is being broadcast live and will also be available to watch subsequently on the Council's website. Members of the public and press may record or broadcast the meeting when not lawfully excluded, provided they show due respect to others in attendance in accordance with Council guidelines. Please ensure that electronic devices are turned off or set to silent and speak clearly into the microphones, avoiding any obstructions to maintain sound quality. We are not expecting a fire drill today. In the event of an alarm, please follow the fire exit sign at the rear of the chamber. Evacuation instructions can be found on page 3 of the agenda. I just have a few announcements to make this morning. Since the agenda was published, Council agreed to alter the allocation of seats at its committees to ensure compliance with statutory requirements. As a result, I would like to welcome 2 members of Reform Group, Councillors Martin Robinson and Heike Sowa, who have now joined the committee. Welcome. The full membership is pending final confirmation and the website will be updated as soon as possible. Members. This is also James Cutting's final meeting before he takes up a new role at Essex County Council. James has served as head in planning for the past 6 years, working closely with his committee throughout that time. I'm sure members will join me in expressing our sincere thanks for his hard work and the support he has given to the committee, and wishing him every success in his new role. Agenda item 1, apologies for absence and substitutions. Rebecca, do we have any apologies, please?
Thank you, Madam Chairman. I've received apologies from Councillor Richard Kemp, who is substituted by Councillor Simon Harley, Councillor Elizabeth Farrow, substituted by Councillor Rob Bridgeman. We've also received apologies from Councillor Lance Stanbury and Councillor Judy Cloak. For today's meeting, the Conservative group will be substituted by Councillor David Roach.
Thank you. Agenda item 2, declarations of interest and dispensations. Councillor Mason.
Thank you, Chair. Item 7, the Widdington recycling application. There's a slight overlap of roles with Suffolk County Council and Haverhill Town Council, of which I am a member. I am aware of the issues and I've had discussions about this matter in that role, but I do not feel conflicted or predetermined. Thank you.
Thank you. Councillor Roach.
Thank you. Yes, similar, same item, but it sits in my division.
Okay, thank you. Are there any further members? No, thank you. Agenda item 3 is the minutes of the previous meeting, and that is to approve as a correct record the minutes of the meeting held on the 22nd of September 2025. We'll do that by general affirmation. Are members happy? Yep, thank you. Those minutes are approved. Agenda item 4. Before we go to agenda item 4, Councillor Robinson is just going to excuse himself as he's not had his rights away training currently, but will come back for agenda item 7. So agenda item 4 is the claim bridleway, upgrade of footpath 55 Bentley. This item concerns a formal application to add a claimed bridleway to the definitive map and statement, upgrading footpath 55 in Bentley. Before we proceed, I'd like to extend a warm welcome to the following officers who are present to assist with any points of clarification. Lisa Armstrong, Definitive Map Officer, Mary George, Senior Definitive Map Officer, and Jonathan Lockin, the Councillor's lawyer. I will now hand over to Lisa to introduce the report, please.
Thank you, Chairman. So this was a formal application for a footpath to be upgraded to a bridleway. It was made on the 22nd of March 2022 by Andrew Bird on behalf of the British Horse Society. It was made with documentary evidence. Caroline Cavill then made a similar application on the 18th of May 2022, also on behalf of the British Horse Society, but she then withdrew her application. So we considered the evidence that they both provided in our investigation. So map 1 is just a location plan, and map 2 shows the claim route, which is along the route of footpath 55 in Bentley, which runs between Potash Lane and Capel Road in Bentley. So the documentary evidence provided by the applicants were the Bentley tide map, Bartholomew's, Bryant's and Hodgkinson's private county maps, historic ordnance survey map, an estate sale plan from 1897, the Suffolk County Council historic record, and just some photographs of the route. The applicants believe that the application route is depicted on Bryant's, Hodgkinson's and Greenwood's private county map, but officers believe that the application route, that the route shown on Hodgkinson's and Greenwood's, it does not actually match the application route as it is located more west on Capel Road. However, the one that is shown on Bryant's map is a better match for the application route. The applicants note that on Bartholomew's map, the route is depicted in the line style of a road, but there is a disclaimer on this map that the representation of a footpath or road is not actually evidence for the existence of a right-of-way. So these maps together can provide some suggestion of a higher status of the route, but they are not strong evidence on their own. The route is shown clearly on the Bentley tide map and is not tideable. Other known roads and current footpaths and right-of-ways are depicted in the same way, but the route could be non-tideable because it was a public road, but it could also be non-tideable because it was not productive, which means that no tithe payments could be collected. The application route is also depicted on various ordnance survey maps. The applicants considered that the solid lines, the width of the route, and the lack of an FP label are all indications of a right-of-way, but officers believe that this only shows a relatively wide route running between defined boundaries, which is more significant in the landscape, but is not necessarily a right-of-way. And also the depiction on Ordnance Survey map is not evidence for the existence of public rights. The applicants consider that the route is shown also as a road on the 1897 estate sale plan, but railway lines, publicly maintainable roads, private roads, and current rights-of-way are all depicted in the same manner. And officers also note that the application route is not mentioned in any of the sale particulars. The parish survey map shows this route colored in blue and labeled. The parish survey statement has a page for this claim with an inscription that's crossed out, reading private farm road used as a footpath by parishioners. It also refers to a gate at Grove Farm.
Madam Chairman, sorry to interrupt, but I think the members of the public cannot hear the speaker.
Sorry. Is that better? Okay, sorry. So the statement refers to a gate near Grove Farm and a gate and stile near the Cases Altered Inn. The route was added to the first definitive map as a footpath, and it was not claimed during the 1961 or 1979 parish review of the definitive map for a change of status. Some photographs were provided by in Caroline Cavill's application. She stated that the no horses or bicycle signs were a sign that these uses occurred historically and that the landowner was trying to prevent them. But officers consider that these signs are clearly a challenge to those uses. In terms of the area rights-of-way officers' evidence, there were some anonymous reports from 1999, 2002, and 2012 about horses using the route. Quite a few reports were made in 2004 by a single reporter who was concerned that horse use was damaging the surface of the path and making it dangerous for pedestrians. As a solution, the then area rights-of-way officer spoke to the landowner about adding some barriers and closing gates on different footpaths in Bentley in order to prevent vehicular and equestrian use. There was also a motorbike notice on the route in 2009, which the landowner tried to stop, and the landowner also reported some cyclists on the route in 2018. In 2021, another reporter noted that there was a new gap in the gate near Grove Farm, which was restricting access and creating an obstruction. The area rights-of-way officer replied that this was an unauthorized structure, and he raised this with the landowner, who said that this structure was only there on weekends, and the rest of the time the route was fully open. In terms of the landowner evidence, Mr. Baker has owned the land for 60 years and he is opposed to the claim. He mentioned that he has taken action to show that this route was not a bridleway. So, for example, he replaced an old rotten gate at the village end of the route for a metal one. He also refers to some locked gates at either ends of the route. He also mentions the footpaths only signs at either ends, and he says that he has challenged and turned back some cyclists on the route over the years. There's also a landowner deposit on the section 31.6 of the Highways Act 1980, where he recognizes that the route is a footpath. His solicitor, Mr. Oakes, also refers to the gates and the signage in his letter. He notes that the lines that were shown on the Ordnance Survey maps indicating impediments are a sign that the route was historically gated at both ends. He also includes details of several conveyances and a deed of gift referring to a right-of-way with or without horses, carts, and carriages for landowners. Mr. Oakes questioned that the applicant's evidence were indicative of a bridleway, and he also noted that the route that they identified as the application route on Hodgkinson's and Greenwood maps were actually the application route. He thought it was a different route that has now disappeared. Mr. Baker, the landowner, when he received the draft report, also noted that the southern gate, which we said was at point C on map 2. Where does it point? This one? Oh, that's fine. Okay, that's okay. It's at point C anyway. But after reviewing the aerial photography and our photographs from the site, we then estimated that the gate was actually between points B and C. So there was no user evidence in this case, which means we did not consider the test for presumed dedication or common law dedication. There is some evidence of horses using the route, but officers did not find any occurrence of this happening without the landowner's permission. There is some circumstantial documentary evidence, but it is not considered sufficient to raise a reasonable allegation of bridleway rights along the route. So the recommendation is to reject the application. Thank you.
Thank you, Lisa. Members, do you have any points of clarification? No. We will now move on to the public participation session, and we have received one request to speak on this item. I would like to now invite the applicant, Mr. Andrew Bird, to come forward to the public speaking table, turn on your microphone, and you have 5 minutes to address the committee when you're ready.
Good morning. I've written a short statement, so I'll just read this. Chair and members of the committee, thank you for allowing me to speak. I'd like to focus the members' attention on the legal test that you've been asked to apply today, which is not whether bridleway rights are proven on the balance of probabilities, but whether there is a reasonable allegation that higher rights subsist. That is a deliberately low threshold. This case contains multiple strands of historic evidence pointing consistently towards higher status. In particular, Bryant's 1826 county map depicts the route in the category of lanes and bridleways. Officers acknowledge that private county maps rarely show footpaths at all. So depiction on such maps is in itself significant. The Bentley Teeth map further shows the route depicted in the same manner as acknowledged public highways and as non-teethable land. Officers accept this indicates public status, even if they consider it is not fully conclusive of bridleway rights. That uncertainty is precisely why an order should be made. Members are also invited to note that the presence of gates or historic stiles does not negate higher public rights. Gates are lawful on bridleways and even carriageways, and case law is clear that they do not of themselves defeat dedication. Much of the evidence relied upon against the application dates only from the mid-1960s onwards. Public rights will have arisen long before that period. Later landowner actions, signage or Section 31(6) deposits cannot retrospectively extinguish those rights. The question before you today is therefore a simple one. Is the evidence capable of supporting the existence of bridleway rights? I respectfully suggest that taken cumulatively, the historic mapping, the teeth evidence, the physical continuity of the route, and the absence of evidence to the contrary, the answer must be yes. Making an order does not create a bridleway. It merely allows the evidence to be tested properly through the statutory process. For those reasons, I ask members to disagree with the recommendation and that direct that an order be made. Thank you.
Thank you, Mr. Bird. Members, do you have any points of clarification? No, thank you for your time this morning. Before we go into debate, members, do you have any points of clarification to go back to Lisa with? No, thank you. I'll now open the debate. Councillor Beer.
Madam Chairman, have we heard from the local member at all?
Lisa?
I'm
Have we
sorry, it was
referred
to
to the
Lisa.
local member?
My apologies.
Has the local member, as a local councillor,
it was Georgia Hall, but no, she's not commented at any point.
Sorry, I didn't hear what you said.
Sorry. Can you hear me now? Oh, sorry. It was Councillor Georgia Hall, but she's not commented at any point on this.
Councillor Roach?
It's just the audio in here this morning. It's very difficult to hear, even you, Chair. It's quite difficult. I don't know if we can just tweak it up a little bit.
We've had IT look at it several times, but people just need to speak directly into the microphone and elevate them and not try and turn their head away.
I don't think I'll have that problem.
Do you have anything on the debate, Councillor Roach, while you're there? No. Councillor Bird?
Well, if you invited me in, Madam Chairman, it seems nobody wishes to debate this, so I'll propose a recommendation that we accept the recommendation of the officer.
I have a proposer. Do I have a seconder? Councillor Stringer?
But before we move to seconding, I just wanted to actually just...
Is that
looking
Councillor
at the...
Stringer?
Sorry.
After we've had a proposer, I need to have a seconder before we can carry on debate.
That's not quite true. But...
Councillor Beer, your second. Okay, Councillor Stringer.
Right, now that it's been seconded, I find it mildly curious that the officer is relating to the evidence as circumstantial. What other evidence is there other than what happens by circumstance? There'll be whatever's written in documentary evidence, but what through this process, what other evidence would we have needed other than circumstantial? I think is probably what I would like to ask the officers.
I think that just was a way to say that it wasn't very strong evidence. So stronger evidence would be enclosure map, railway plans, etc., which would be more indicative of the public rights existing.
Councillor Drummond.
Thank you very much, Chair. My view is that, looking back to the times when this was mapped, it's highly likely that people were on horseback. I mean, it was just a way of getting about, wasn't it? So I'm actually not going to vote for the recommendation. I would have voted the other way, and I will vote the other way. I think that the bridle way probably existed and should exist now.
Councillor Bird.
Yeah, we seem to have prompted some debate now, obviously, as the proposer of the motion that we accept. I think, to be honest, Councillor Drummond, you'd need more evidence than just simply to say, well, at one point, before we had cars, people rode horses. Well, then that would be evidence for, every road and path in the country to become a bridle way, simply on the basis that years ago people rode on horseback. That isn't evidence for a particular bridle way in a particular location. We need, as the officer has pointed out, far more substantial evidence than that. We need it marked on maps, just to say, well, that footpath there needs to become a bridle way because 200 years ago people rode on horseback, so they must have ridden on that path on horseback. That's not sufficient evidence. It would be even lower than the circumstantial evidence that Councillor Stringer was referring to. The circumstantial evidence is at some point in 2004 somebody might have ridden on that path on a horse, but to just say years ago they must have done because everybody went on horseback isn't sufficient evidence.
Councillor Harley.
Yeah, thank you very much, Chair. I'm in the neighbouring division, although I don't believe there's any predetermination or conflict. I would just like to say that I have walked this footpath very many times and would have no objection with sharing it with horses, I think that would in many ways seem appropriate, but I would be concerned that opening up this footpath to a bridleway would enable use by cyclists, particularly electric cyclists, and although generally I'm in favour of cyclists, I believe that would cause significant issues with both horse riders, pedestrians and damage to the path.
If I could just intervene, if I could just remind members to focus on the evidence for rights. We're not here, we may all have opinions about how useful a route might be, but we need to put those ideas out of our mind and just look purely at the evidence where the rights exist.
Are there any further members that would like to debate this? No, so we have a proposal from Councillor Bird, seconded by Councillor Beer, and that is officer's recommendation. It is recommended that the formal application is rejected with all parties being advised accordingly. All those in favour? Against? That item is approved. It's carried. Agenda item 5 is the claim restricted byway, Ickenham Road, Brandon, Elvedon and Wangford. This item relates to a definitive map order modification concerning a claimed restricted byway along Ickenham Road in Brandon, Elvedon and Wangford. I'd like to extend a warm welcome to the following officers who are here to present to assist with any points of clarification. David Last, Definitive Map Officer, Mary George, Senior Definitive Map Officer, and Jonathan Lockington, the Council's lawyer. I will now hand over to David to introduce the report, please.
Thank you, Chairman. It's the general area of the claim on map 1. I'll move on to map 2, which is a bit more precise. This is a formal application for a restricted byway known as Ickenham Road. The original formal application was covering Brandon, Elvedon and Wangford. The formal application was made in September 2021. As the County Council hadn't determined the application within 1 year, the applicant exercised his right to seek a direction from the Secretary of State, which he did, and the County Council were directed to to determine the order, determine the claim, and were given a deadline of the 11th of February 2025, which obviously we have clearly passed, but this was deliberate because the route is originally claimed linked to another route, which can be seen on map 2. This claim is the route that sort of heads southwest from A, with the restricted byway symbol, which is the PEC line with V's along the middle, and that claim links with a road which runs near west to east at the bottom. It was waiting to find out what was happening with that claim, which we were directed to make an order for, and was advertised in September 2025 and has received objections. So once we knew what was happening, we could then proceed with this case. As it happens, once we started the investigation, the main item of evidence is the enclosure award, which was the enclosure map, is dated 1807 with the award 3 years later at 1810. If I move briefly on to map 3, what we did there was we overlaid the enclosure map onto modern mapping to try and establish where the route was, and it turned out it was actually nowhere in the vicinity of what had been claimed. The applicant has looked at this and accepted this and accepts the route as we've overlaid. I believe the applicant has also written to all members of the committee recently, and he provided you a copy of the enclosure map. That's the line that has been overlaid onto modern mapping on map 3 there. So if I go back to map 2, so the route was set out on the enclosure map and in the award as Ickenham Road, which usually at the setting out in an enclosure award we would take as conclusive evidence, and we would be making a recommendation on the hire test to record it as a public right-of-way because of its enclosure set out. But in this case, from 1807, 1810, when the award was done, there's no trace of it afterwards at all, because There is also a requirement, whilst it is conclusive evidence, that it needs to be shown that the route has come into existence or accepted by the public. In most cases, we're about to find it appearing on later, as a physical feature on later Ordnance Survey maps, which were produced from the 1800s onwards. In this case, this route does not feature. So the original draft report that went out, I was actually recommending a rejection of this claim, as it could not be shown that the route had come into existence, despite it being made by a legal process. Mr. Andrews raised some points at that draft stage, of which he is summarised in the correspondence he sent to you all, and I have dealt with, within the report anyway, mainly between paragraphs 50 and 53 of the report in my conclusions. Mr. Andrews does raise a reasonable argument. Within the description, it does describe the route as continuing on its current course, which could mean, yes, it was a route they were looking to protect, or it could possibly mean it was a route that was on the ground which they wanted to make public, from the council's view. Did it exist as a legal route before the enclosure ward and they were trying to retain it? Evidence for that, unfortunately, is slim. There was only 2 items that come up. There's a depiction on Hodgson's map on a similar alignment. Hodgson's map, however, is a privately produced map which is known for its inconsistencies, and we wouldn't usually put a lot of weight behind it without other stronger evidence. And there's an 1802 diversion order map relating to a different route, of which this claimed route features on there as a line, but with no indication as to what it is or what that line is, whether it's a public route, whether it's an estate track, or what it was. So the only 2 bits of evidence pre-existing the enclosure are not strong evidence. But there are the 2 tests. There are the reasonable allegation and the balance of probabilities. And as I said, Mr. Andrews has put forward a reasonable argument, and that's why we're minded to change our original thought of rejecting it to recommending it based on a reasonable allegation, because we can't ignore the fact that it was under a legal process. But after the award, it just cannot be shown what happened to it, whether it came into existence or not. So that's why the recommendation is to make an order based on a reasonable allegation.
Thank you, David. Members, do you have any points of clarification? Councillor
Thank you, Madam Chair. Can I ask, has the local member made any comments?
No, we haven't received any comments from the local member.
I'll now move on to the public participation session, and we have received 1 request to speak on this item. I'd like to invite an objector to the application, Mr. Andrew Ben-Kieran, to come forward to the public speaking table. Turn your microphone on and you'll have 5 minutes to address the committee when you're ready.
Good morning, everyone. Thanks for the opportunity to come and speak to you. I'm Andrew Blenkiron, the Managing Director of Elverdon Farms, and I speak on behalf of Elverdon Estate and Elverdon Farms. I wish to object to the proposed definitive map modification order and ask the committee that the committee do not make the order recommended by the officer. I would like to explain a little bit of the context as to why I think that the order should not be made, as there is insufficient evidence to support it for the purpose of the statutory test. Briefly, and in terms of context, we at Elverdon feel as though we're being subjected to a concentrated campaign by the applicant, Mr. Andrews, who is trying to exploit the statutory provisions contrary to their purpose, and this is causing a drain on both our resources and those of the County Council. Mr. Andrews has already caused us and the County Council to have endured no fewer than 2 previous public inquiries regarding proposed byways and his so-called Lake and Heath Road. At both the 2002 and 2013 inquiries, the inspectors rejected Mr. Andrews' proposals. As your officer report explains, Mr. Andrews is now trying yet again to establish partially the Lake and Heath Road. In this instance, the inspector who allowed it to proceed concluded that the test of a public right-of-way being proven on balance is not met. Only the lower reasonable allegation test is. Unfortunately, this has required the council to make the order. Your officers are asking you to make the order not because they consider the evidence to prove the public right-of-way, but because there is a reasonable allegation. Without doubt, yet another drain on the public purse for no tangible reward. We already have 54 kilometres, over 30 miles of public rights-of-way across Elvedon, and that's not to mention a number of permissive paths and massive open access land. It really makes no sense for us to have to deal with another order on such flimsy evidence. As the committee are well aware, there are 2 tests under the Wildlife and Countryside Act of 1981, where the council can make a definitive map modification order. There's the subsist test, where the public right-of-way is evidenced and on the balance of probabilities exist, and there's the reasonable allegation, which is obviously lower, which we've discussed. Your expert officers have concluded that even on the information that Mr. Andrews has spent so much time amassing, he has not demonstrated that this claim, public right-of-way, actually exists, so the higher test can't be met. I would suggest that evidence here does not even pass that reasonable allegation test. Paragraph 5 of the officer's reports states there is no user evidence, and the only documentary evidence of any sufficient weight showing public rights is set out in the Brandon Enclosure Award. Whilst usually this would be conclusive evidence, it needs to be shown that this route came into existence. Officers consider that no evidence has been found to show that this happened, and as was discussed, insufficient evidence to show that the route pre-existed the enclosure award as a public route. However, in setting out the enclosure award, it cannot be ignored, obviously, and the lower test may be met. The recommended route is a cul-de-sac, as there is insufficient evidence for the alignment of any continuation into any neighbouring parishes. There is no evidence of anyone using this claim public right-of-way. The committee can see in paragraphs 35 and 36 of the report that Elvedon Centre Parks have included information from very long-standing employees going back many decades, and no one has used this supposed path. Indeed, there is no history of any public use in anyone's living memory, and this is a very long way from cases where people who have been walking their dogs for many years have been suddenly removed. The officer's report does seem to rely on the documentary evidence from the Brandon Enclosure Award of 1807. However, as I can see from map 2 of the report, and has been mentioned, the overlaying of the 2 routes, they do not match. And the report acknowledges this in paragraph 13. You can also see from paragraph 37 of the report that even Mr. Andrews, now having read the officer's report, acknowledges that fact as well. Paragraph 5 of the report also explains that officers rule out this route pre-existed the Enclosure Award of 1807, so that deals with Mr. Andrews' efforts to rely on the Quarter Sessions Order of 1802. Your officers have gone through this rest of the historic evidence and found nothing sufficient to support this claim. As the officer's report explains in paragraph 5, the order...
Thank you, but I'm afraid I'm going to have to stop you there as your time is up. Members, do you have any points of clarification? Councillor Sowa?
Thank you very much, Chair. You would like us to reject the application, is that right? And your arguments are that there is not enough evidence for it. Is that right?
That's correct.
What is the impact? What would be the impact if we would go ahead with the recommendations? Can you outline the impact, please?
The impact that we're concerned about is the potential for this route, if it's the order is awarded, for it to potentially link in with the officer's report that another suggested route has been put into the public domain as well.
I'd just like to, I never like to cut somebody off when they're in the middle of talking, but just to remind that the impact of this is irrelevant to the determination, and it's purely the evidence that we need to be discussing.
Thank you very much. It was just because he was cut off before he ended, so I thought I might get more information out of the public speaker. Thank you very much.
Members, do you have any further points of clarification? Thank you very much for your time this morning. Before I open the debate, do any members have any further points of clarifications for David? Councillor Drummond?
Thank you. Do we know anything about this gentleman, Mr. Andrews? Is he a local, or is he just somebody who's trying to make sure that all sort of public rights of way are open across the whole country?
If I could just interject again, the identity of the applicant is somewhat irrelevant, and again, we're looking at the evidence as to for the existence or non-existence of this right-of-way.
Councillor Stringer?
I'm just trying to get my head around the various maps. The claim is on page 46, A to B, 47, sorry, A to B. Can I just check that?
A to B is actually what's been recommended as the reasonable allegation. The actual original claim is the dashed line with the V's in the middle, the restricted byway symbol that heads more or less from A, but on a Waverley course heading southwest to link up with what's the Lake and Heath Road claim down at the bottom of the Centre Parks. That was what was originally claimed. It's when we overlaid the historic mapping, we found it's nowhere near that.
I've got that. I've got that now. So A to B on 47 is what's on the enclosure map 1810.
Correct.
Right. That's the bit I just wanted to bottom out. So in your report, you are suggesting that map triggers the reasonable allegation.
That's correct, yes.
Thank you.
Members, do you have any further points of clarification? Councillor Bridgeman?
Yeah, thank you. Just wanted to clarify, because I may have missed the end of the answer. When you overlaid the maps, they didn't match up.
When we overlaid the maps, that didn't match up to what Mr Andrews had claimed, the claim route as depicted, that lengthy route from A down past Centre Parks. That is what he claimed. That's what it looked like. It was just sort of maps beside to each other. That's what he believed was the continuation of the claim route, because there was other bits available. But we actually managed to do a digital process of digitally overlaying the maps and aligning them so they all fitted with other known features. That's how we got what we believe to be the most accurate alignment we can of the Clickham Road of A to B, which, as you can see, isn't the same as what was originally claimed.
Councillor Stringer?
Just got another question to our legal officers, actually, just so I get my head around this fully. So if someone makes a claim that they thought there was a route between A and B, does that trigger, as it were, like a fishing expedition from us to look at any other routes that might... Because frankly, if someone says, I think a route went from Ipswich to Felixstowe, but we found one that went from Ipswich to Stowmarket, surely you need to ask the right question at the beginning of the claim, or do we just blanketly look for anything that goes in that area?
Well, it was because the claim was based on the enclosure award, which Mr Andrews believed was the other route. So it's the enclosure award which we investigated. It's not a case of looking to see what other routes might exist around the area. Taking that enclosure, his primary evidence, and overlaying it is how we come up with a different route. And then we've got a discovery of evidence which we have to act on.
Are there any further members who'd like to ask for points of clarification? No, thank you. I'll now open the debate. Councillor Beer?
I think, Madam Chairman, the comments we've heard and the evidence and the explanations that have been given, I think that leaves us only one conclusion, is to follow the officer's recommendation, reluctantly, but I'll propose it. Thank you.
So that's a proposal for the officer's recommendation. Do I have a seconder? Councillor Stringer?
Yeah, thank you, if I can. I think we would have to second this, because I think it does trigger the reasonable allegation that the map is quite clear, even though the original claim was looking at a different, perhaps a similar starting point, but a different destination. So, but I take on board the comments of the speaker that it definitely hits that lower level, but I'm not so sure there's enough to hit a higher level, but that's what we're being asked to do. So thank you.
We have a proposal and a seconder. Are there any other members that would like to enter debate? No, I'll now move on to the vote, and that is the officer's recommendation. It is recommended that a modification order be made under section 53C 3CI of the Wildlife and Countryside Act 1981 to add to the A to B to the definitive map as a cul-de-sac restricted byway, incorporating the particulars contained in paragraph 59 into the definitive statement. All those in favour? Against? That item is approved. Agenda item 6, Cavenham Quarry. Agenda item 6 has been withdrawn from today's meeting to allow for a revision of the development description and re-advertisement of the application following the applicant's undertaking of further works without planning permission. I will now just go and give members a 5-minute break quickly. Members, if you can be back at 10:55, please. Welcome back. I'll now move on to agenda item 7, which is Haverhill Waste Management Site, Faulkner Road, Haverhill, CB9 8QE. This is a retrospective planning application for the construction of a materials recovery facility and associated infrastructure. I'd like to welcome back the following officers who are present to assist with any points of clarification: James Cuttin, Head of Planning, Andy Rutter, Development Manager, and Jonathan Lockington, the Council's lawyer. I will now hand over to Andy to introduce the report, please.
Thank you very much, Chair. So, agenda item 7. Before I crack on with the presentation, there is just some slight amendments to the report. You'll have them in front of you. So, it's an amendment to paragraph 7, which is the recommendation. So, it's just fleshing that recommendation out a bit more. So, it's that originally it was that planning permission is granted subject to the conditions as set out in Appendix A and a Section 106 agreement. And it's just been split into two, and Part B just provides a backstop for us, really. So the new recommendation is that it's recommended that A, that planning permission is granted subject to the conditions as set out in Appendix A and a Section 106 agreement for a financial contribution of £11,660 for delivering planting and 10-year contribution to maintenance. But also B, so this is the backstop, that the Executive Director of Growth, Highways and Infrastructure or the Assistant Director for Housing, Economic Growth and Planning to be authorised to refuse planning permission in the event that such legal agreement has not been completed within the period of 6 months following the date of the committee, as requirements necessary to make development acceptable have not been secured through a Section 106 planning obligation. The grounds of refusal being that the applicant did not enter into a Section 106 planning obligation to provide a financial contribution towards the mitigation of the loss of trees forming visual amenity, and the application being contrary to the policy GB4 of the Suffolk Minerals and Waste Local Plan and policy SP7 of the West Suffolk Local Plan. So what that means is if the Section 106 isn't entered into within 6 months of the date of this committee, then you'll afford delegated authority to refuse the application.
So, Madam Chairman, could I just ask a clarification point on what has just been said? Could you just confirm to me, little a, plan permission granted, subject conditions as set out in blah blah, 11,660 for delivering planting, and is that a 10-year financial contribution for maintenance, or is it just 10 years for them to maintain it?
So the figure quoted is the price ultimately of the planting, the labour and the maintenance for 10 years after it's been planted.
So there's no financial commitment for 10 years, it's just to maintain it?
No, it's just to maintain it.
Sorry, and that's normal?
Yeah, yeah. So, as the Chair read out, this is a retrospective application for the construction of a materials recovery facility, also known as a MRF, and associated infrastructure. And so, well, why is the application appearing before you today? Part 3 of the County Council Constitution sets out what powers officers have delegated to them. In this case, the application has received objections from Haverhill Town Council and over 4 public objections. Therefore, it has to come to this committee. So, I've got some pictures later on of the site, so this won't mean a lot at the moment, but if you just bear with me, the site is outlined there in red. You've got the stars indicating the objectors to the site. So this gives you a bit more context to the site. It's located on Faulkner Road Industrial Estate in Haverhill. You can see surrounding industrial estate. To the east, to the west, you've got almost that green corridor. I believe that's an old railway line. And then you've got residential to the west, and there is some residents just to the north as well. So I mentioned Falconer Road. So Falconer Road is almost the spine road through the industrial estate. This is at the end of Falconer Road, so you've got the site immediately in front of you. The access on the left-hand side of the picture isn't anything to do with this site. So you're clearly looking at the building to the left. You've got a weighbridge right in front of you. You've got some metal gates, and you've got the weighbridge office. So where I'm stood now, if you look to your right-hand side, you'll see the access into some further industrial estate. So you've got the site offices on the right, and then as we just move through, you've got car parking and some already permitted industrial uses there. So I've now walked into the site, I've turned around and I'm facing Falconer Road. So the main body to the site is behind you in this photo. You're facing back out. This is, that's the weighbridge, and you've got the weighbridge office there. So I've then turned back round into the site. You've got the storage of skips, and then if we just come round, this just to show some of the types of materials on site. So it's, this stockpile here is called CD and E waste, so that's construction, demolition and excavation waste. It's just kind of standard building waste. You've then got the open-sided MRF building here. So you've got 5 metre high push walls within the MRF, and then you've got an odour suppression system you can see in the ceiling of the MRF, and then the lighting, and you've got commercial waste there at the moment. So I've not added loads of plans because the pictures show what the development is, but this is just cross-section of the MRF building. On the left-hand side, the middle, you can clearly see there's solar PV on top of the building, and then you've just got general cross-sections of the building. So, as I mentioned, we're here because we've had Haverhill Town Council object to the application, and we've also had 9 third-party representations, and they cover the following material planning considerations. So we've got air quality, including dust, noise, odour, vermin and vibration, and specifically Haverhill Town Council then also objected on the following material planning considerations, being noise, mud on the highway, odour and vermin. As I mentioned within the table paper, this application, if you were to approve it, would be subject to a Section 106 agreement, so the permission wouldn't be signed until the Section 106 agreement has been signed. So just as a reminder, a Section 106 agreement is a legal planning agreement made between a person or persons with an interest in the land and the local planning authority. It's secured through Section 106 of the Town and Country Planning Act 1990, hence why it's called Section 106. A Section 106 agreement must meet the following necessary tests. So these are slightly different to planning conditions. With planning conditions you have 6 tests. With Section 106 agreements there's 3 tests. So it's got to be necessary to make the development acceptable in planning terms. It needs to be directly related to the development, and it's got to be fairly and reasonably related in scale and in kind to the development. And as I set out earlier, this Section 106 agreement secures a scheme of replacement planting outside of the land ownership of the applicant. And, well, where's the planting going to be? So the draft Section 106 agreement at the moment is between ourselves as the County Council, West Suffolk Council as landowner for these other sites, and the applicant. So it's proposed that the financial contribution is made to West Suffolk Council to deliver the planting on behalf of the applicant, and as part of the draft Section 106 agreement, the following land parcels shown on the plan have been identified as potentially suitable for delivering that planting. And If you resolve to approve the application, further work will then continue with the Section 106 agreement to then decide which piece of land, and then there's conditions attached in Appendix A which set out the detail in terms of soft landscaping, density of the planting, the species, how they'll be planted and maintained. So that's included as a condition. So the reason we need the Section 106 is due to the retrospective nature of the application. Some existing planting was taken out on the site before the construction commenced and before they applied for planning permission. So this will cover the loss of that planting, and then there'll be, although this application isn't subject to statutory biodiversity net gain, there will be still a biodiversity net gain. So just a very high level summary, just to remind you what the application's for. So it's a retrospective application for the construction of a materials recovery facility and associated infrastructure. I consider the application to be in accordance with National Planning Policy Framework, National Planning Policy for Waste, the Suffolk Minerals Waste Local Plan and the West Suffolk Local Plan. So therefore, my recommendation is that planning permission is granted, subject to the conditions as set out in Appendix A and the Section 106 agreement for a financial contribution of £11,660 for the delivery of planting and 10-year contribution to maintenance. Or then B, that the Executive Director of GHI or the Assistant Director for Housing, Economic Growth and Planning be authorised to refuse the planning permission in the event that the legal agreement is not entered into within 6 months of the date of this committee if the application is approved. Thank you, Chair.
Thank you, Andy. Members, do you have any points of clarification? Councillor Beer?
Yes, just on page 91 on what you've said, consultation, Councillor David Roach is present, but have we heard from the Nick Timothy, the MP?
No, we haven't. We wouldn't normally consult the MP, but he showed interest before the application was submitted as a retrospective application, so we included him, but no, we haven't heard anything from him through the application.
Councillor Drummond?
Thank you, Chair. I'm trying to find out from reading the papers exactly who the applicant is. I mean, is it us? Is it a third party? I mean, if it's us, it certainly must be remiss of us to get ourselves in a situation where we're having to apply for retrospective planning permission.
Yeah, so the applicant isn't us. The applicant is Woodington's. Let me find. So it's Woodington Recycling Limited by the applicant.
Thank you.
Councillor Goldsmith?
Yes. How long has this plant been operating before the application come in? And have we had any complaints from the residents before it came in?
Let me just double check on the dates for you. So the site, in terms of overall site history, I believe has been in a waste management use for, well, since at least 2013. And that was with a previous operator. The building and the use kind of intensified around 2022, 2023. And we negotiated the submission of a planning application. Subsequently, there wasn't enough information to validate the application at that point. We proceeded to serve enforcement notices, which were appealed, but then it was negotiated that the appeal would be withdrawn subject to a full planning application with all the requirements coming forward for consideration, and so the appeal was withdrawn, and this is where we're at now in terms of this is the application we're now considering.
you put your microphone on, please?
Yes, complaints. Yes, so yes, we've had complaints obviously through the planning application. We've had objections, but there were several complaints. I've covered a lot of the issues already in terms of the complaints. At one point, there was household black bin waste coming onto site, and that was particularly smelly. It was in the summer. The applicants committed to not processing that sort of waste, and it doesn't make up part of this application either.
Councillor Mason.
Thank you, Chair. The situation as described probably doesn't present the frustration that was demonstrated in the community at the, and I use these words accurately, unholy stink that was caused, which has prompted this retrospective application. And, you know, the organic waste was a particular problem for the community and surrounding businesses. I've got a couple of points of clarification really regarding the vehicle movements. So the site will open at 6, no processing of materials as set out at the moment till 7. Of course, vehicle movements on site, and they're predicting 56 a day, when they're reversing and moving around, there's a certain amount of sound pollution. Did the sound assessment take into account those quantity of vehicle movements, and also between, for example, at the moment 6 and 7 o'clock, what impact that could have on the neighbouring community? Can I just ask you to go to slide 13 before I finish? Now, the reason I say this is to the north. Can you go? No, sorry, slide 14. To the north, where it says proposed site location, there's actually a residential property there. And the site, the operating site, has been extended right onto the fence line of that neighbouring property. And so for any vehicle movements, it's going to have quite a profound impact on that neighbouring property. So one of my first questions is, are we satisfied that this sound assessment has taken that into account? Also, the close proximity and the change of use of that yard next to that property, has lighting assessment been taken place? Now, in fairness, during the summer months, it's obviously light early in the morning, but there will be quite some profound light pollution, certainly during the winter months, with the site opening at 6 o'clock in the morning. Has an assessment been done as to the impact on that particular residential property? I've got some further ones, but I'll stop there. Those questions were about sound and light. I'd like to come back for a second. Thank you.
Yeah, thanks very much. In terms of, so obviously I'd never encourage a retrospective application. I'd never encourage a developer to undertake works without planning permission, but what does happen is, if the site is up and running, instead of the predictions of noise levels, you're able to measure what is going on at site already and what the potential impact could be, or is already taking place. In this case, we're satisfied in terms of noise, that all the correct receptor locations have been identified and been taken into account.
Sorry, can I just come back on that? So I'm very focused on the times between, for example, 6 and 7 o'clock in terms of vehicle movements and reversing and those reversing sounds. Thank you.
Yeah, the answer is yes, it's been taken into account in the noise report. So in terms of noise, that's been taken into account, and in terms of lighting, yes, there's a lighting assessment, and that's been deemed acceptable as well.
Okay, so moving on to dust suppression. Local businesses on the estate have long complained about dust on their vehicles. Many of these are commercial operators. They do drop-offs and as part of their deliveries. It would appear that the dust suppression isn't functioning as intended. Now, in the report, it didn't seem to suggest that that was an issue. It's clearly an experiential issue for people in surrounding businesses. So do we have sufficient enforcement measures in place to make sure that those sprinklers, when there's that dry waste being processed, isn't creating sufficient dust? Because of course this is cumulative over time, and if it takes a week to cover a vehicle, it's still unreasonable that those businesses are being so profoundly affected. Thank you.
Yeah, again, really good question. So with minerals and waste sites, you often get the same type of mitigation proposed. It's the industry standard. So that the type of measures that are to be employed is that drop heights to be minimised, things like dampening down of materials, sheeting of HGVs, the fact that the site is hard standing and it's not soil, and we've got the conditions on there to basically they're enforceable. They'll make the operator undertake those mitigation measures. But in addition to that, there's been an air quality assessment and dust impact assessment submitted. It's been reviewed by our air quality consultants, West Suffolk Council, EHO, and that takes into account things such as historical weather conditions, wind directions, things like rainfall, wind speed, and most importantly, the receptors and how close the neighbours are. And that's all been taken into account, and the consultants are happy with that.
Councillor Roach.
Thank you. A couple of clarification points on definitions, please. 21 on page 91, it says for sorting onward transfer of construction, demolition, commercial skip waste. So I'd like a definition of that, because that's also repeated in the conditions on page 120, subsection 15, and it says non-hazardous inert construction, demolition and commercial skip waste shall be accepted. That commercial skip waste looks to be a woolly item, because obviously inert waste we understand, but commercial skip waste, could we have creeping organic waste into that from commercial sources? And that's the worry. So Councillor Mason was quite right in some of the odour from the site was such that people couldn't sit in their gardens. If you look at the map there, the green bit to the south of the site looks to be a fair bit away, but you've got Ashley Road, Ashley Close in those residents. But that bit of green is a natural amphitheatre, so it's any sound comes across and it's amplified because the sound can't get out. It's actually that green bit is actually a bowl, so it does affect things. So, but a definition of that first, please, Andy.
So, in terms of commercial skip waste, that again, that is not intended to be any organic waste. And if you'd like that to be reflected, I'm trying to think of a word more clearly in the conditions, well, that's something you can consider for a debate.
Thank you. I think it's important we do. And then the other one is coming back to noise, because I think in the report you said when they were doing the sound receptors, when we were looking at noise, they couldn't measure some of it because of construction going on over the road. So it does worry me about the operating hours, 6 o'clock. So although they're not moving plant, if you're loading a lorry up with a skip or moving a skip off the back of a lorry at 6 in the morning, that's quite a lot of noise. So I'll perhaps look at, when we get to it, perhaps thinking about some variations to the hours, but that's it. But yeah, I'm really concerned that we tie down that commercial skip and the inert waste so we get it nailed down.
Councillor Harley.
Yeah, thank you very much, Chair. In the amendment in paragraph 7, it says that in paragraph A that planning permission is granted subject to the conditions set out in Appendix A in the Section 106 Agreement for Financial Contribution for planting and a 10-year contribution to maintenance. Does this refer to the Landscape and Ecology Management Plan on page 117, where it says that there's a 5-year period of aftercare for the trees that have been planted? Does this mean that there should be instead a 10-year period of aftercare? Because in the life of the sapling, there's quite a big difference between 5 years and 10 years.
Yes, you're quite right. That's a typo. That I would that would require to be amended. So that's condition 5. So it'd be for It would be for a 10-year aftercare period instead of a 5-year. So that's on page 117.
Thank you.
Madam Chairman, so on condition 5, following this debate, the condition would be amended after the Waste Planning Authority setting out implementation, 10-year aftercare and long-term management objectives and prescriptions instead of 5-year. And on the skip waste point that Councillor Roach highlighted, which is, excuse my paper, on condition 15 on page 120. We could clarify that condition further so that we insert and non-putrescible, as in not the stinky stuff, so that it's only non-hazardous and non-putrescible inert construction, demolition and commercial skip waste shall be accepted.
Councillor Mason.
Thank you, Chair. Just a point of clarity. I do have another point to make. Are we at the stage where we're discussing conditions, or do we do that during debate?
We do that in debate. We've still got public speakers.
So that just threw me a little bit.
Points of clarification to the officers.
Okay, so a question for you, Andy, is regarding the sites identified for the S106 planting. Both sites are quite biodiverse rich, in fairness. And I'm just intrigued by the process by which those sites were chosen, as opposed to, I'm thinking of Puddlebrook, for example, where there's much more scope for biodiversity. Why are those two sites? Is it their close proximity? But as I say, they're quite biodiverse rich anyway.
Yeah. It's a good point. They were ultimately selected by West Suffolk Council as these are the ones which we think are most appropriate for the type of planting that is to be undertaken, and also their proximity to the sites have been taken into account.
Members, do you have any further points of clarification for Andy? Councillor Stringer?
It's mentioned on the plan that there'll be solar panels on the roof. What I was looking, I couldn't find, is there any policy in West Suffolk's plan that make commercial buildings have renewable energy on them? I couldn't find it, because I couldn't find it. You might show it on the plan, but is there a policy that makes sure it happens? I think is where I'm going.
Yeah, bear with me 2 seconds. Yeah, what comes to mind when you ask that question is in the Mid-Suffolk local plan there is a policy that says all commercial, not verbatim, but basically all commercial and industrial buildings shall have decentralised renewable energy supplies. Not that I'm aware of in the West Suffolk local plan. There isn't that requirement, James.
There is a sustainable construction policy. I will find that for members as we're going into debate.
Members, do you have any further points of clarification? Councillor Mason?
Sorry, Chair, I'm trying to think ahead to the debate and just getting clarification on one issue. If the dust suppression system fails to work, under the planning application and guidance that they've received, would they then have to cease operations until it is working when they're processing dry materials?
It depends on whether we view it as expedient to undertake enforcement action or not. So enforcement action is discretionary, and if if there's a big impact we can identify, then there's no reason why we wouldn't or couldn't undertake enforcement action. We've got different notices available to us, including temporary stop notices, breach of condition notices.
So that wasn't quite what I asked. Is would they, if their dust suppression system wasn't working, would they undertake themselves to stop work, or would they be instructed to by the council if dust was becoming an issue? What I'm trying to avoid is a situation where dust suppression becomes optional.
Yeah, the dust suppression won't be able, it is not optional because it's part of the planning conditions. They could decide to stop off their own back if their machinery broke, but also we've got methods which we could make them stop ultimately. Okay.
Members, are there any further points of clarification? No. That will move us on to the public participation session, and we have had 2 requests to speak on this item. I'd like to invite an objector to the application, Mr. Robert Watts, to come forward to the public speaking table, turn your microphone on, and you have 5 minutes to address the committee when you're ready.
Firstly, I'd like to thank you for giving me this opportunity to come and put a few points over which might be relevant, might not be relevant, but they're very relevant to me. So I live in Sturmer End House, which uses it's got a boundary line between my back garden and part of the site in Lowry Court, which is on the site layout plan. So the north boundary is in my back garden. And so after 2 odd years of Widdington's operating without any planning permission or under some enforcement, I gather that they were meant to be not operating until 7:30 while they were under enforcement, but actually they still started at 6 o'clock and 5:45 and all sorts of things. So the part in this noise emission thing from SRL, I don't know who they are, but it says the closest residential receptors are on Ashley Road, approximately 70 metres from nearest site boundary. Well, I would have a bit of an issue with that in the sense that my boundary is their boundary. So, but on to noise. What I'm asking for, or what I'm hoping to get, is the quiet enjoyment of my life back. These guys are operating, and that's fine, I've got no problem against business, but the noise from that site. If you go into Lurie Court from my back garden, the proposed parking for all the guys that are going to work there must be, I don't know, 18, 10 cars, whatever. But it sounds like a symphony of car doors going off before 6, after 6, fine. So that's the first port of call of noise in the morning. And it's not a very nice dawn chorus, but as you get to 10 past 6, the skip bins get dragged along the floor, and Christ knows what's going on, but there's a hell of a din. To be fair, not every day. I must say that, not every day. Monday mornings is bad, you know, and days of the week that go by. And of course, there's various different levels, depending on, bear in mind I've been operating a couple of years, so I've had a couple of summers and I've had a couple of winters. Well, the summer brings a different problem, apart from the dust, the noise, the smell. The guys operating in the workshops work outside in the yard. Now, they want to work until 2 o'clock on a Saturday afternoon, but grinding, changing wheels, and this, that, and the other, out in the yard is a particular nuisance to me and anybody else around. The compressor in the summer, with the doors open, the compressor kicks off sometimes just after 6, but bizarrely, none of that happens in the winter when it's cold. No one works out in the... so I would like that to be considered in anything, if that at all can happen. But my main problem is the noise, yeah? Obviously the smells and everything might have been dealt with this thing, but my main concern is as well the hours. Now, where is it? I would like, what I would like, here we go. There's hours that they were meant to be under the enforcement, 7:30 to 5:30, Monday to Friday, and Saturday 8 till 12. Well, that never happened. But what concerns me is the statement attached to them. Well, it's to do with the operating hours. They are totally different to the trading hours.
Mr. Watts, I'm afraid I'm going to have to stop you there as your 5
Have I
minutes
done
is
5
up.
minutes?
You have, yes.
Okay, well, do you get my gist?
I'll bring members in case they've got any points of clarification they'd like to ask you.
Okay.
Councillor Beer?
Thank you. Yes, my first question to you is, you were alluding to it, but are you under the impression that their operation hours are 7:30 to 5:30? Well, and you're saying they start earlier than that?
Under the enforcement, they should be working, or I was told by this gentleman over here, they should be working from 7:30 to 5:30. In actual facts, they started at 6, before 6. That's what's going on now.
Thank you. And my other question is, you had lots of complaints about noise and some suggestions of how to improve and the difference in winter and summer.
Yep.
Have you spoken or taken this up with the management committee there or the people concerned? I just want to know what conversations you may have had or communications.
I've taken it up with James. And, you know, to be fair, he's put a 6-foot fence only, so let's say half of the boundary. But what was there prior was a 10-foot fence. So it had more of a sound deadening effect because, unfortunately, their ground rises up. So they're in an elevated position to start with. So there's no point in having a low fence. You know, the noise is coming up and there's nothing to stop it. My advice, even just out there, just before we came in, my advice to him was to put in a bigger fence. I understand. Look, I think it's going to get passed, right? This is what I think. It's going to get passed. And I'm here just to let you know that I'm losing my quiet enjoyment of life, and I look to you guys to preserve that.
Thank you. I understand all that. You said you've spoken with James. Who is James?
James is Mr. Whittington over there.
That's not the applicants.
Well, he runs the plant.
Right, okay. As long as we're all clear on that. Thank you.
Yeah.
Thank you. Yeah, okay, thank you.
No worries.
Councillor Goldsmith.
You say that that there's a lot of work in the summer. It's noisier because they work outside. The noise that's created, is it in conjunction with the recycling plants, or is it actually vehicle maintenance?
Both. In Lurie Court, which is adjacent to my house, they have opened up into the yard out the back, which is where the recycling's done. But you get the beeping of the vehicles going between, you know, the thing. I just don't know. In the summer, everything seems to be louder at that time of the day. And I think one of the councillors touched on it. Was this noise emission test done at that time of day? I don't know. Doesn't say.
Councillor Bridgeman.
Thanks, Chair. So, Saturdays, operational hours. What did we say they were, and what do you think they are?
Well, in conjunction with a firm that is 100 yards the other way, they have just received planning within the last year from West Suffolk Council doing similar stuff, aggregates, this, that and the other. And their trading hours should be 7:30 to 5:30 Monday to Friday and 8 till 12. So one of my questions to this gentleman over here was, is there a difference between Suffolk County Council and West Suffolk Council? Because I was thinking that would be the same, but I don't know.
And currently, we say that's 8 till 12. Currently what?
Currently they'll go till 2. Yeah, currently they'll go till 2. And they start at 6 on a Saturday.
Right, okay.
Right? Which, you know.
Councillor Harley.
Yeah, thank you very much, Chair. Thank you very much for your testimony. It comes across very clearly. I would just like to ask about the summer months. You mentioned there's a difference. Is there a difference in terms of smell or vermin or flies or any other evidence of organic material?
There was all of that. Smell, vermin, flies, you know. To be fair, I only see one rat, but apparently it's happening further down. But needless to say, it's more elevated in the summer. You're out in the garden more, but stuff during the summer, the smell, the problem they had, was all in the clothes, on the washing line, and the dust was an issue. And bear in mind, I've lived there 21 years. And when the chap was saying it's had previous use, nothing like this, I can tell you. You know, that is, it's on a different level.
Members, do you have any further points of clarification for Mr. Watts? Thank you for your time this morning.
Am I done?
You're done, thank you.
Thank you very much.
I would like to invite the representative for the applicant, Mr. Mark Levers, to come forward to the public speaking table, turn your microphone on, and you have 5 minutes to address the committee when you're ready.
Good morning, committee. My name is Mark Levers. I'm a chartered surveyor and planning consultant for Whittington Recycling, who are the applicants for the application at Haverhill. First, I'd like to begin by addressing the retrospective nature of the planning application. As planning officer, I advise retrospective applications are never ideal, but they are not inappropriate, provided that the development themselves is acceptable. When we started putting together when we first started looking at the site, we were in the process of putting together a very detailed planning application. So there has, just to make it clear, there's been never any intention to ignore, bypass or undermine planning. There was always an intention to submit a planning application. It was down to timing that works commenced before full application was ready to go in. Whittington's worked proactively, constructively, and engaged fully to all requests for information and commissioned a comprehensive suite of assessments to back up the development on site, and the outcome of that is a detailed planning application that you're now considering. Turning to the concerns raised by objectors and local people, it's important to consider both the causes of those issues and the steps that have been taken to address. So the majority of concerns have been made in relation to noise and dust. And the majority of those, if not all of them, have ostensibly been due to noise and dust created during the construction phase, which is particularly dusty, rather than operational phase. The construction phase is now almost completed. There has been no significant dust issues that I've been made aware of in the last 12 months. I've worked closely with the EHO, I've worked closely with the Environment Agency, and we've been working very hard and proactively to ensure that we control dust odours as much as we possibly can. In terms of odours, yes, there were some that arose as a consequence very early on during the operations when some putrescible waste was brought to site. It was evident that mitigation of odours that the site employed was not sufficient to ensure that it couldn't control it adequately, and as a consequence of that, the company took the decision not to take any further putrescible waste, and that was introduced into the planning application. The waste streams that we're now looking at bringing into site are, as has been explained, limited to construction, demolition, and skip waste. Just to give an indication on skip waste, it's effectively because construction demolition usually comes away in large vehicles and is concerned with large-scale development, whereas skip waste, as you will be aware, is the kind of waste that comes from your household. So it's highly unlikely that that would contain any putrescible waste because it's mainly pots, pans, plasterboard, wood that's come from people doing DIY, generally what comes in from skips. The site issues have all been adequately addressed as far as we're concerned. We've been working closely with the local authority and the EHO and the Environment Agency. All the various issues and impacts have been reviewed by statutory consultees, and in each case, no objections have been raised, subject to the enforceable planning conditions which we'd support. It's also relevant that in terms of the location of the site, it is located on an established waste management site, and the development represents a modern purpose designed waste management facility. There are clear positive benefits outside of this in terms of the solar panels that provide green energy. The site supports local investment, local employment, and provides an important additional local waste management service, as currently I believe there are only 3 material recovery facilities in the whole of Suffolk, as noted by the Environment Agency. The Haverhill facility therefore promotes recycling and reduces the need for wasted travel longer
distances. I'm
distances.
afraid your time is up.
Yes, thank you.
Points of clarification. We have Councillor Beer.
Thank you. The hours, I just want you to confirm the objector said that you're starting at 6 a.m. in the morning, 6:15, when the hours should be 7:30 to 5:30. Can you offer any comment on that as to going forward how you would take this on board? Because unless he's telling a deliberate lie, there must be some merit there that I think that you or this James should be looking at.
Yeah, so
that's my first point.
Yeah, so just to be clear, I think in terms of hours, there are two sets of hours that have been put forward. One is operations at the plant, which will be from 700, and then there is the vehicle movements, which are from 6 o'clock in the morning. So there should be no operational noise generated by the site until 7 o'clock. That's including maintenance or any recycling operations. So it's purely down to drivers turning up and going off site with their trucks from 6 o'clock. In terms of the vehicle, in terms of the hours that were mentioned previously, they were put forward in the enforcement, so the 7:30 to 5:30, which was withdrawn. So it's the application hours are from 0600 hours until 7 for vehicle movements, and then from 7 in the morning until 6 o'clock is the operational periods, Monday to Friday.
Sorry, so to be clear, it is not 7:30 to 5:30, it's 7 to 6. Okay, thank you. My second point was about the noise, dust on the highway and odour. That seemed to come out loud and clear. What can the locals do to bring this to your attention to get you to try and solve some of these problems? Because whilst you're saying that you're there to try and stop this, and some of the things that you commented on, you were improving on, it doesn't seem to be working. Now, whether the objector needs to speak to somebody else or this James, I don't know. So I do think you have a slight problem there.
So again, in terms of objections received, we've worked proactively, and in fact there is a informal liaison committee that's been set up where I attend with the business units to the, get my orientation right, east of the facility, so that whenever there were any concerns in terms of noise, dust, whatever it might well be, then I was happy to meet up and we discussed why and then what we were going to be doing about it. In terms of, so I know that we mentioned about what happens if the dust suppression system doesn't work. There is a dust environmental management plan that's been submitted and forms part and parcel of the planning application that includes an obligation on behalf of the developer or the operator that if they cannot adequately control dust, for whatever reason that way may be, then they have to cease operations until they can adequately rectify the situation. So it's either a change in weather conditions or maintain the dust suppression system. In terms of noise and dust, again, those issues arose predominantly during the construction phase, and as far as I'm aware, I've not received any complaints, either individually or from the EHO, for the last 18 months. There may be ones I'm not aware of. I'm not saying there aren't any. It's just that all the ones that I've been meeting up with local businesses to discuss, I've not had any dealings with them and need to for the last 18 months.
Thank you. My final point was the operation and construction, the dust and noise. I think you just hit on it a little bit there, but that does seem to be where some of the complaints were coming from.
So again, there's the dust environmental management plan to rely on in terms of controls of dust. In terms of noise, there are statutory noise limits that are imposed on the developer, on the operator, that they must meet, irrespective of where whoever's being impacted. It's around the 360 degree boundary of the site. the operator has to meet noise limits. So if there's a particular concern in some area, then we'll do the noise monitoring, we'll establish what it may be that's causing those problems and mitigate in order to comply with the planning conditions.
Thank you.
Members, just quickly, on page 120 of the agenda, under item 17, that has got the proposed operational hours, if that helps you. Councillor Mason?
Thank you, Chair. I don't think it's in any question that this waste processing site has been there for over 20 years. Well, my understanding is there's been processing there. Can you correct me there, Officer? But my understanding is there's a long history of operations on that site before Whittington.
Sorry to interject. Is this a point of clarification to the public speaker?
No, it was just leading into something.
So is it something that we can address then in
okay.
public?
Well, look, the point I'm trying to make is, would you consider yourself to be a good neighbour in terms of having gone the extra mile in terms of wanting to mitigate some of the concerns, particularly to sound? In your speech, you didn't mention the residential property to the north of the site. And, you know, can you kind of quantify the measures that you've taken to try and mitigate those concerns?
Yeah, thank you. We were aware that, again, during the construction phase, we received complaints regarding noise from the residential properties to the north. That actually was more to do with the tonal nature of the noise rather than the duration and the loudness, but it was also aligned to vibration. So when the site was being developed, it needed to be compacted down. It was the compactor that was giving rise to those concerns. We worked with the EHO who liaised with the complainant. We stopped working during specific times of the day because I think they worked at night and so they were asleep during the day. So we stopped working during specific periods of the day and reduced the number of hours that the vibrating roller was utilised to ensure that the complainant was kind of position was protected, which I think it kind of, we didn't receive any continued concerns by them. So the EHO said that they kind of closed the books on that one.
Sorry, if I can come back on that. So I think my main concern, is there enough operational discipline on the site that operations don't occur, the dragging of skips before the stated times of operation? You know, being a good neighbour is also about making sure that everybody on site know the terms and conditions by which operations should be taking place.
Yeah, I entirely agree. The whole purpose of having a modern and state-of-the-art development is to ensure that it carries out its operations both effectively, but also to minimize any impacts and certainly doesn't give rise to unacceptable impacts beyond the site boundary. If there are things that need to change on site in order to ensure that that happens, then the site needs to carry those out. There are, again, within the environmental management plans, an ability to review what the plant is doing and to amend its operational procedures to ensure that it reduces any potential impacts as far as it possibly can. There is also an environmental permit that's associated with the site that also has similar constraints. So the Environment Agency will also check to ensure that noise, dust, odour, vermin, flies, all these things that have been raised as concerns are also properly controlled. So it's not just down to the local planning officer, or it's not even down to a local complainant to act as a policeman for the site. The Environment Agency there undertaking regular site visits, again, to ensure that the site is operating properly. Again, what happens where sites have a propensity to give rise to prolonged unacceptable impacts as far as the local residents are concerned, and I attend several liaison committees, more than happy to look at attending liaison committees on this instance so that any concerns can be raised, so it doesn't get to a point where you have to put a formal complaint in. You can just approach either me or the company to say, by the way, can you just turn it down or make sure that you address this issue? And then the company will do all it can in order to address those. The company wants to be a good neighbour. It doesn't want to cause problems in the neighbourhood.
Councillor Roach.
Thank you, Chair. You just alluded earlier on when you were doing your thing about vehicle movements, and you were saying that the drivers just could come in at 6 o'clock, get in their vehicles and go. Are you saying to us that they definitely don't drag the skips and load those onto the lorries before they go out,
No.
and that's all done, so they just drive out? Because we understand that skips are dragged and loaded onto trucks early. So you're telling me that doesn't happen?
No. What I'm saying is that they get their vehicles. So part and parcel of them, the reason why there's usually a distinction between drivers arriving on site and taking their vehicles out and operations is because you're going out and collecting waste. So you need to be on the road before you start operating. It's a kind of a standard procedure for waste operators. As part and parcel of them leaving the site will be to load up with skips. Ideally, you do the skip movements the night before, so you're not doing it in the morning. That doesn't always happen because of whatever reason. It might be operational, it might not be available to do that. If there is a requirement to load the skips, then again, they should be looking to minimise noise so that they do not exceed the statutory limits that will be imposed under condition. So it doesn't matter what they do or how they do it, there's still a limit there. If they're exceeding it, they need to change their operations to ensure that that doesn't happen.
Councillor Harley.
Yeah, thank you very much. The other gentleman mentioned that there was use of compressor, presumably for cleaning equipment. I have personal experience of these. These can be incredibly noisy and often come on very abruptly and in quite a startling manner. Can you tell me how much those are likely to be used in the continuing operational procedures?
Sorry, I'm not an operator, so I can't comment on operational matters in terms of things like compressor. Again, all I can state is there are limits in terms of noise that they have to adhere to, so again, it doesn't really matter what they do, how they do it, provided that those noise limits are adhered to.
Councillor Robinson.
Thank you very much. Early on, the resident witness said that the ground was, I think, falling away from your site and that your fence had been reduced in height. Would you agree with his comments?
So, yes, the Lurie Court, which is an existing offices and there's 2-3 industrial units. They've been there. What's happened is that the main site, where the MRF is, was acquired, and separately Lurie Court was acquired. So Lurie Court provides the administrative and also maintenance facility for the main site. That does drop away, so there is the boundary with Robbie is lower down than the site entrance and also lower down than the MRF site, but the MRF site I don't think is the issue that causes Robbie. The causes for concern is mainly to do with, I think, Lurie Court itself. So there is a fence line that runs along Lurie Court in between the two properties.
Can I ask the resident, the witness, to confirm that, or is that not allowed at this point?
We're just on the applicant now. Councillor Beer.
Just coming back on a point in your answer to Councillor Roach, I believe you said that there would be no dragging of skips or loading before 7 a.m. onto lorries in the morning. Is that correct?
So, no. If I did, I misspoke. There will be no operations. So The materials recovery facility, just to explain what it does, you take waste in, it then effectively will sort it into a series of recycled materials. So it could be crushed concrete, wood, plastics, and then there'll be non-recyclable material which goes off-site. So the actual sorting, crushing, screening, and hand sorting of material, that should not happen until 7 o'clock in the morning. So the only thing that happens between 6 and 7 should be drivers turning up, loading their vehicles with empty skips, and then going off-site. So there'll be no maintenance or actual recycling works happening on site.
Can I just clarify for members, this is on page 120, condition 17. Operations authorised by this permission shall only be carried out between the following times: 0600 to 1800 hours, Monday to Friday, 0600 hours to 1300 hours on Saturdays. There should be no operations on Sundays or bank holidays. Between 0600 to 0700, there shall be no operation of the excavator, crushing equipment or material handler. Those are the proposed operational hours.
So just to be very clear, they can load their skips between 6 and 7 onto a lorry.
Yes.
That's unfortunate. Thank you.
Councillor Stringer?
Yeah, it was actually a question to the officers arising from that. One of those including the fact that clarifying that condition, that it's not moving an empty skip is not material handling, but equally is not part of the operation, but it is part of the operation. What I wanted to also focus on was this maintenance issue. I know certainly from other operations, waste operations, that maintenance is excluded from all other operational hours normally. So are we saying that no one can maintain? So if someone turns up to the lorry and it's got a flat tyre, they can't fire up a compressor and do that until after 7 o'clock in the morning. Is that correct?
Sorry, is this a question to the public speaker? We're still in public speaker clarification.
Members, do you have any further points of clarification? No, thank you for your time this morning.
Thank you.
Following all public speakers, I would now like to bring the case officer back to respond to any comments or questions or issues raised.
So I've made a note of a couple already, so if I just start with those. So Councillor Stringer, you asked about sustainable construction. Yes, this is policy LP1, sustainable design and construction, that basically sets out that certain things must be taken into account, such as active travel, environment, design and building. It doesn't say thou shalt have renewable energy. And the final question that Councillor String just asked was in relation to maintenance, and the condition is worded as all-encompassing, so that includes maintenance, that includes, unless it's specifically stated it doesn't include maintenance, then it does. So if they would have a flat tyre, if they would turn up at 6 o'clock and had a flat tyre, they wouldn't be able to, they would be able to, they'd be able to do it. So the only operations which are excluded before 7 are the operation of an excavator, crushing equipment, or material handler. When we say material handler, it's grab, stockpile. Okay.
Councillor Stringer, did you have anything further?
There were some more questions, yes, before I was stopped. So we've clarified that. There was mention of a fence being erected. Is that an acoustic fence or just a normal fence? Okay. So the reason that, let me get this right, the reason the material handler, etc., and the crushing equipment cannot go before 7 is because of the noise and dust that might arise.
Noise.
Noise, okay. Yes. So the movement of an empty skip isn't noise?
It is noise, but it's considered at an acceptable level.
Really?
At that time, yes.
I'm just asking because I live near several building sites, and I can tell you that the loudest noise on any of those building sites is the moving of an empty skip. By far the loudest noise. So we've identified that noise level of that skip, those types of skips, and they're acceptable.
Yep. So the noise assessment specifically identifies different types of operations, and that's how it's been able to identify that the operation of the excavator, crushing equipment or material handler is unacceptable between 6 and 7, but the other operations are acceptable at that time.
Councillor Mason.
Thank you, Chair. I note in the planning application paragraph 83 says policy LP8 states that proposals for major non-residential development should demonstrate how any specific health and well-being needs to the community will be addressed. And also 85, where proposals for development should maintain or create a sense of place and have regard to local context. I think the testimony today from the objector would suggest that we need to tighten some of the conditions. That there's just a few, but I'm going to ask whether it's possible. Firstly, is it possible and reasonable to condition an acoustic fence to be installed along that boundary line?
No.
Secondly, West Suffolk Council have a similar processing site as operation hours 7:30 to 5:30 to include the prevention of skip movements. It's pretty much anything that is causing disturbance because of the close proximity of that residence. Can we change those operating hours so that there is less disturbance? Because quite clearly skip movements are an issue. So can we condition a change so that not only no vehicle movements or operating before 7 o'clock, but also if skip movements, it would force essentially the company to prepare their skips the night before or after 7 o'clock.
It's within your gift to propose a amendment to the conditions. However, I don't think that specific change is required to make the development acceptable. That's a legal test. So there's 6 legal tests to imposing planning conditions. I don't believe that that's necessary to make the development acceptable. Our noise consultants haven't identified that either, nor is West Suffolk EHO. With regards to the site down the road, that's a different operation. It's apples and oranges, because if it was the same, it would be a county planning application. And you know, you've got things like different topography. You've got you've got things such as different barriers in between those sites and the residential property. So it's my advice that that change is not required to make the development acceptable.
I'm just uncomfortable with the history that we've had in Haverhill of Widdington's. The retrospective application has come in because of the uproar that was caused.
Councillor Mason, we just need a point of clarification on this application.
It was about the condition. Oh, I'll stop now.
Councillor Bird.
Yeah, thank you, Madam Chairman. Forgive me if I can take this back to basics, because obviously most of the discussion over the last half an hour, 45 minutes has focused on this nearest resident, and I've been struggling to actually pinpoint where it is. My first question, can you actually show me on one of your maps where this gentleman's residence is?
at the label proposed site location, there's some green space there. That's where the property is.
Sorry, grid space, sorry,
The green, so on the plan on the screen,
Yeah.
you've got the label proposed site location.
Yeah.
There's a green area of vegetation just to the south of that. So in between, that's the same plan. So you've got the label that says proposed site location in the middle of the plan. You've then got the red line around the industrial units. It's in between the red line and where it says proposed site location.
Okay. I suppose my next question is, which came first? Because with that description, it leads me to ask, why on earth is there a house in the middle of what seems to be an industrial estate? So was the house there and then this industrial estate grew up around it?
I wouldn't be able to comment unless it's not relevant to the determination of the application.
My next question then is, if I understood it correctly, when the resident who's objecting spoke, he suggested or hinted that your report and all the measures and commentary about noise and odour was on the basis that the nearest residents were in Ashley Close. Is it the case that your assessments on noise, odour, smells, whatever, do take into account that he is the nearest resident, not Ashley Close?
Yes. So the comment he referred to from SRL, who are our noise consultants who review the planning applications, was in relation to the closest resident to where the waste processing is being undertaken, is my interpretation of that. But upon review of the reports, the correct residential receptors have been taken into account.
Councillor Drummond.
Thank you, Chair. One of my questions has been answered in the question that Councillor Mason posed. Going back to condition 15, I recall earlier that James suggested that we could add non-putrescible waste into that list. Obviously, non-hazardous inert can't be putrescible, but would you be happy that we added those words into that clause there?
If members want to make it clearer, then that's within your gift. It will still be achieving the same purpose of the condition at the moment. So yes, that would be fine.
Councillor Beer.
I think I'll leave mine until debate because I think the officers can respond then.
Councillor Bridgeman.
Yeah, thanks. Obviously, being quite new to this committee, I was just looking around the generalised stuff. How often does retrospective planning come in?
I couldn't quantify it.
Is it unusual?
No, but it's not something that we can take into account. The fact that it's retrospective cannot be taken into account, and you can't take into account any past performance of the operator either.
Members, do you have any further points of clarification? Councillor Robinson.
Thank you, Madam Chair. The way the conversation has gone, we have the objecting resident who, if I'm not mistaken, suffers from the fact that prevailing wind is taking noise in his direction. There's the fall of the ground, so that the current fences and the low fence is not really providing any kind of cover to stop the noise. And yet the question was, could we instruct a higher fence to be put in? It was very clear, categorical no. Is there anything else that we could condition to help the resident?
The conditions, as I alluded to earlier, are those that meet the 6 tests as set out in the MPPF. So that's It's, you know, that they're enforceable, that they're reasonable, that they're proposed to make, they're there to make the development acceptable, being among them. I believe the conditions as proposed are necessary to make the development acceptable. There isn't any over and above those included that spring to mind that we could include. These are fairly standard conditions. They give us good levers to, if a site was operating outside of hours, you know, I think it's very clear what the operational hours are. It opens up avenues to serve certain notices if we need to, meaning they're enforceable conditions. But there's nothing over and above that's been included that I would recommend.
Councillor Bird, you're ready for the debate. Are there any further points of clarification to the officers? I'll now open the debate, and Councillor Bird.
Yeah, thank you, Madam Chairman. I've listened carefully to everything that's we've heard today. Obviously, whenever I judge any planning application, I know that you have to leave emotive arguments out of it. You judge it purely on its merits. You judge it against policy, and also I'm aware that there is a presumption in favour of sustainable development. So any planning application, your starting point is that you approve it unless there are good and reasonable reasons not to. And having heard the officer's presentation, having read the report, everything in a sense leads one to saying we should approve of this. It complies with a whole string of NPPF paragraphs 86, 116, 187, GP1 and GP4 from the Waste and Minerals Plan. So the whole report, the legal framework leads you to say, yes, should we approve of this? But then having heard local members who are aware of it, and particularly the resident, I then have not just concerns, but what I think are legitimate material planning considerations to question this. And I think a lot of it comes down to, I mean, we can't rewrite history and somehow move this gentleman's house outside of being in the middle of an industrial estate. We are where we are, but it comes down to these operating hours. And I take on board the officer saying what, in his opinion, would be reasonable conditions and ones that you could impose to make the application acceptable. But I do beg to differ, because it seems in determining the operating hours and what can take place, there seems to have been just an arbitrary decision made. We've gone through all of the different things that can happen there. Workers arriving in their car in the morning and slamming their door, moving containers, and then the excavator, the crushing equipment, and we've made an arbitrary decision. We haven't just said no activity shall start until that start. We've put some activities in ones where the noise is acceptable and other activities where the noise is unacceptable. So given that people arrive to work before the time that you have to, you can't arrive at 1 minute past your starting time. So given that people are going to arrive and slam doors of their car even before the start time of 6 o'clock, and then at 6 o'clock they can talk to each other, they can shout, they can open doors, they can move containers, but it's only until 7 that they have to wait to use an excavator, crushing equipment and material handler. That simply doesn't seem acceptable to me. I think we need to move towards, I mean, every other aspect of the application I'm content with. It's there, we need it, and we need that activity to go on a waste handling site. But we need to have a discussion of moving all activity until not just 7, possibly 7:30, given that some of the noise that the resident has to suffer is them arriving and slamming car doors even before they actually start. I think we need to be moving till possibly 7:30 as a start time for any activity, given that even with 7:30 they would probably start arriving anywhere between 7 and 7:30. But obviously I'll listen to other members on that. But I think, you know, my view is yes, I'm moving towards approval because it complies with all the other conditions, and we accept that there needs to be this activity on the site, but we need a serious discussion about the noise, and as I say, to arbitrarily divide up the activities and say we know that all of the activity makes some noise, but some of the noise is acceptable at 6 in the morning and other noise is only acceptable at 7. That just doesn't seem sufficient for me.
Councillor Beer.
Thank you, Madam Chairman. Well, Councillor Bird has stolen a lot of what I was going to say, and for most of us, I would think, but I think he's quite right. I have great respect for our planning officer. He's the expert, and he's conducted it very well, as he usually does. But I do feel that this is a situation where we're meant to take all aspects into play here, and I think, as Councillor Bird has said, the hours should be, I would make a slight concession on yours, that we say everything starts at 7 o'clock, nothing before 7 o'clock, and we must be able to alter that somehow. And my second point would be that if a fence can be erected at the bottom of this gentleman's garden, which would help, perhaps the applicant would take it on board to try and talk to them and achieve that, because that would help. And it's a small cost to you, it's a great cost to the owner. And the applicant's shaking his head, so he's not unhelpful towards that. And I think they want to try and solve this problem, but I think it is important. The local members have said about this activity before 7 o'clock, and I fully support that. I will be very happy to move a recommendation if we can go forward that everything stops and doesn't start until 7 o'clock. Thank you.
If that was a proposal, Councillor Beer, is there a seconder? Councillor Drummond?
Madam Chairman, can I just clarify if that was a proposal and if that also included the amendment to condition 5, which was to change it from a 5-year aftercare period to a 10-year as well, as we clarified earlier?
Yes. I accept all your other points.
Okay, and Councillor Beer, does that include an amendment to 15 for the addition of non-producible to the waste types?
And apologies, was that 7 or 7:30? Was
the concession that perhaps 7 o'clock, but that's to be adhered strictly by the applicant, and they can make that happen. So we don't need to go to 7:30, and so I'm quite happy. And they're shaking their heads, so that they want to move forward on this as well.
Councillor Drummond, did you second
Thank you. Yeah,
what Councillor Beer said?
I do second it, but I just want to say a few words. So thank you for adding the non-putrescible. Thank you for extending the care from 5 to 10. I am fully supportive of changing the start time to 7, because as it is at 6, I have a factory in Newmarket, and people arrive a good half an hour before they start. So 5:30 in the morning is the middle of the night as far as I'm concerned. So this poor gentleman next door, he's getting no sleep. So it really isn't fair. So certainly 7 as the start, but it triggers that we now have to change D as well. So we can't say between 6 and 7 at D if we don't start till 7. So I think we need to change D to 7 to 7:30. Thank you.
Councillor Mason?
Thank you, Chair. Councillor Drummond, I would just like to support your slight amendment there. I think the operational movement shouldn't be starting till 7:30 with people arriving on site from 7. I think that seems a good way that the applicant can be a good neighbour for certainly the property to the north. This application should, there's no reason for this processing site not to be approved, but it's about how we can ensure that it is being a good neighbour, and I certainly support that condition. Thank you.
So may we just clarify the condition 17? So 2 options have been floated in my mind. One being that it's an all-encompassing condition, so operating hours shall only take place between 7 and 6, so 7 in the morning and 6 in the evening? Or are you saying we still include D, which as currently drafted is between 0600 and 0700, there'll be no operation of the excavator, crushing equipment or material handler. I think Councillor Beer mentioned that can't take place before 7:30.
Madam Chairman.
If I could help my colleague here, I've noted down, instead of 6 o'clock in the morning, that becomes 7 o'clock in A and B. And in D, instead of 6 o'clock, it becomes 7 o'clock. And instead of 7 o'clock, it becomes 7:30. Yes.
Councillor Roach.
Thank you. I'm happy with those changes to the conditions. We've picked up the one in 15 as well, haven't we? With non-putable. Little bit of history on the site. It was a concrete crushing plant in the day. I think it was 2012, 2013 when it came on. The house in question has been there before the industrial estate was built, so it's built. The estate is built up around it. When it was a concrete crushing, this is just a bit of history, but when it was just a concrete crushing plant, they were limited to only operating, I think, 4 days a month, actually operating the actual plant. And then Whittington came in a couple of years ago and built the building, and we are here where we are. For Councillor Bridgeman, retrospective applications in the waste industry are common. We get them all the time. We judge each application on its merit, so that's fine. But I'm happy with the conditions that's changed, that it can go forward. I think, did we see there was a nod of a head for some acoustic fencing along the, yeah. So I think that covers off as much as we can do on this. So
I don't think it's conditioned for the acoustic fencing.
no, it's an agreement. Yeah, we can't condition it, but it's an agreement. So on that basis, as amended, I'd be happy to support it.
Councillor Sowa.
Thank you very much, Chair. I just wanted to mention to everybody that it is an industrial estate, and Culina starts their lorries early morning, much more before 6 o'clock. So actually operational hours from 7, but giving them the business the opportunity to have the containers unloaded from 6 o'clock onwards wouldn't be that unusual, because it's an estate. It's an industrial estate, and when you go there at 5 o'clock in the morning, there are lots and lots of activities. It is not a farm which is quiet or anything like that. It is very busy area, and from 5 o'clock in the morning, you have big traffic already. So I'm not too sure if you really want to go ahead with the 7 o'clock, because yeah, okay, right. Okay, but in my opinion, it doesn't make a big difference, because it is industrial estate. It is noisy from 5 o'clock in the morning. You will see people going there, workers arriving, lorries movements, and everything. Thank you.
Councillor Bird.
Yeah, sorry, Madam Chairman. I just wanted one further clarification before I know what I'm voting on. Following on from Councillor Beer's comments and Councillor Roach's, Are we talking about acoustic fence, not just a fence, but an acoustic fence? And secondly, is it simply a request to the applicant to think about putting one in, or are we conditioning that they must put an acoustic fence in?
We can't condition something. You have to look at the proposal in front of you. There is no proposal for a fence as part of this application. I thought it was agreed that we could include a note, or the applicant and the operator has already potentially made a note that they will discuss that with the neighbour. But it's not something that's in front of us today. It's not part of this application, but we can include a note at the end of the permission.
Yeah, yes, Madam Chairman, that's exactly how I intended it to be. The neighbour and the applicant can get together, and hopefully they'll come up with what is suitable. Yes, if they can go that extra further on the fence, that will help, but I think that's something we must accept, that if he's prepared to help the neighbour, that's as much as we can ask for. We've gone forward and stopped them starting at 6 o'clock, so I think it's a win-win all round for everybody. Thank you.
Are there any further members that would like to come and debate? So what we have in front of us is, as of the table paper, under item 7 for A and B, that's been changed by the officers that we've already heard. We've also got under item 5 on page 117 that the tree planting is from 5 years to 10 years. On page 120, item 50, the addition of words of what can't be put in the skips. And then again under page 20, under item 17, the operational hours under A from 7 a.m. till 6 a.m, B 7 a.m. till 1 p.m. on Saturdays, and D of between 7 a.m. and 7:30 in the morning for those items.
Sorry, Chair, would you just mind going through those times again? Because I think I heard 6 a.m. to 6 a.m.
Sorry. Under A, 7 a.m. to 6 p.m, B, 7 a.m. until 1 p.m, and D, 7 a.m. until 7:30. And then we've also got the note of the applicant to have discussions with the neighbour about fencing.
Chair, may I, sorry, don't mean to prolong, but condition 16 reflects the waste types from condition 15, and that wording should be amended to match condition 15 in terms of the non-protestable.
So I just checked with my proposer and seconder that you're happy to add the additional words in on 16 on page 120 as well. Yeah, you're both happy with that. So all those in favour of the recommendation? That's unanimous, that item is approved. That concludes today's Development and Regulation Committee meeting. Thank you everyone for your attendance and contributions today. Before you go, the next meeting of the Development and Regulation Committee is scheduled to be held at 10 a.m. on Tuesday the 3rd of February 2026. The next site inspection reserve date for planning matters is scheduled for the morning of Friday the 30th of January 2026. This meeting is now closed.